Welcome to the Family Law Frontline.
Welcome back to the Family Law Frontline with Fedor Kozlov. Fedor is the founding partner and chief litigator at the law office of Fedor Kozlov, PC. With over a decade of experience in Illinois family law, he handles high-stakes cases involving custody, property division, domestic violence, and complex divorces. I'm Leanne Lyon, and today we're talking about emergency custody in Illinois and what it really takes to get immediate court intervention. Hello, Fedor.
Hello, Leanne. It's nice to be back.
Great to see you. Fedor, when a parent calls you saying that they need emergency custody, what is usually happening in that moment that makes the situation feel urgent?
It's a little bit difficult to answer in a few sentences. So the emergency custody obviously has to do something with the minor children. And it can be, I would divide it into two different subgroups. One, if we're talking about well-being of a child, right? And two, if we're talking about something else, let's say a violation of a court order. Usually these things in these matters brought up via emergency petitions. And I saw emergency motions many times. The thing is here that what's emergency and what's not emergency, it's for the court to decide. Usually when people file emergency petition, the first thing they have to prove is that it's really an emergency. So if you have a custody agreement with your spouse and your spouse is late to drop off the child by 20-30 minutes, it's not an emergency. It's probably an emergency to you because you have to pick up the child and go somewhere else, but it's not an emergency for the court purposes. Emergency has to be something that is really emergency. And if court doesn't react, then something bad can happen. So the examples from my practice that I remember now from the top of my head, one was when a mother was going back to Russian Federation and was taking children back to Russian Federation. That's an emergency because if you don't have a court order, you might never be able to bring the children back. When emergency like that happens, the court would issue an order and the custody would go back to the other parent, but only on a temporary basis. So it's not going to be a permanent emergency or permanent emergency custody. It has to be on a temporary basis, and the other side, in accordance with the due process, will have to have a chance to explain herself or himself. Another emergency situation I experienced or change of custody was when the mother again moved from the residence more than 25 miles away to a different state, to the state of Indiana. So that was an emergency because first of all, it was in violation of the law. Second of all, it was in violation of the court order. And third, no notice was given to the father. And that's what's very important in this emergency situation. Usually emergency appears when the other side doesn't know what's going on with his or her child. And this is all about notice. People do make decisions, adults make decisions that sometimes lead to, sometimes have negative consequences. And the reason is simple. You have to understand that you are two biological parents of the child, and you have to notify each other what you're doing with the child. You don't have to notify them of your personal activities, but anything that has to do with the child, you have to let the other side know. You go to a doctor, you have to let the other side know. You move, you have to let the other side know. So these emergency situations happen when the other side, one of the sides, doesn't say anything. Another emergency that can lead to custody or switch of the custody or full custody on a temporary basis when there's a physical harm to a child. So, and that it can be many things. It can be domestic violence. It can be domestic violence between two biological parents, or there's a fight between the mom and her new boyfriend, or a child simply didn't get back home from school for whatever reason. I was late. And remember that the parent who is in custody of the child is responsible to take care of this child. And if the child is missing or things happen. So one of the cases that we had when a mom, again, a mother, very busy person, and we got it. She has to pay her bills. She worked two jobs. She dropped off her child at the daycare. The problem was that the daycare's hours, usually authorized by DCFS, were from 7 a.m. up until 3 p.m., I think. So the mom made a deal with the daycare facility where she would drop off a kid at 6 o'clock in the morning, which is not authorized by DCFS. What happened was that she dropped off the child, got into her car, and went to her work. And the child walked away, and the child was found on the street by a neighbor. And that was a big deal. DCFS was called, police was called, emergency motions were filed. Now, if we have extended family, and if we have a mother and a father, then the custody would go until the issue is resolved over to either a biological parent or somebody else. In that case, there was no father, and the child was taken by foster parents. And that was a big issue. So DCFS, the daycare lost its license, and the mom was not able to see the child for about 6 months until she got the child back from DCFS. So when we talk about something very serious, like child endangerment, abuse, neglect, things like that, DCFS usually is involved. And that's when we talk about a switch of custody. When we talk about things like moving out of state, moving out of country, being late, things like that, then usually one of the sides would file an emergency petition, and we would only deal with the court of law. And of course, the child, at that time, the court would appoint a child representative or a GIL to figure out everything that's going on with the child, how dangerous situation was, what should be the consequences, and things like that.
So, what does the process actually look like procedurally? Are these motions filed ex parte, and how quickly does the other parent get a chance to respond?
Well, what's ex parte? Ex parte is a communication with the court without another side being present. It's an exception to due process. So due process of the law says that any communications with the court must be made with the knowledge and notice to the other side. Ex parte communications occur only in exceptional situations when time is of the matter and you cannot waste any more time on notices and things like that. Most common ex parte communication is when we talk about domestic violence. And of course, domestic violence may include not only a spouse, but also children. So if there is a domestic violence and there is a danger of physical harm to a child, the custodian of that child can file an ex parte motion, emergency motion. What it means is that this person, either through a lawyer, or usually it's done pro se, meaning that the person would do it himself or herself, would go to court, fill out motion, file a motion, and they would go in front of the judge the same day, sometimes the same hour. And the presiding judge, would determine if there is a serious danger to the life being of a child, and if emergency ex parte motion can be granted. If the motion is granted, then the other side still has to get a notice. So if you get the order of protection and you include yourself and your child in that order of protection, that paperwork is given to the sheriff of the county where you filed it. That sheriff will go over to the household of the other side, or maybe your household if you live together, and the sheriff would serve the other side with the notice. You still have to give the notice to the other side. Due process of the law tells you that the other side must be notified and must defend, like given an opportunity to defend himself. Usually with the orders of protection, with ex parte communications, you will get a protection for about 2 weeks. So you can file your motion, you will appear in front of the judge, the other side will get that motion. If you need to get back to your home at the time when the motion is served by the sheriff would most likely ask the alleged offender to move out of the residence and stay away from alleged victim. But in 2 weeks, you go back to court. And you go back to court and the other side is on notice. If the alleged offender, doesn't show up, you're going to get it by default. But if he or she shows up, they can bring a lawyer, you can bring a lawyer, and you will have a hearing in front of the judge. Now the emergency ex parte order of protection goes into plenary order of protection, which means that you can extend it for 2 years, up to 2 years. You can extend it up until 1 year or 2 years. And this is usually how the civil order of protection works with ex parte communications. Again, I must underscore that it's civil, it's not criminal. Even if I'm not talking about DV cases. DV means domestic violence when there's a criminal order of protection. If you have a criminal order of protection, this is something that's filed by the state and the prosecutor. But if you, with the civil order of protection, it's still civil. It becomes criminal only if the alleged offender violates the order of protection. And this is also important to understand. The violations can be of any kind. Even if, let's say it's a he, let's say there is order of protection, he understands that he did something wrong and sends you flowers, it's a violation of the protection. If he sends you a text message saying, I love you, get back to me, it's a violation of the order of protection. If he calls her mother or her sister or kids or anyone else, it's a violation of the order of protection, it becomes criminal, and now you have 2 cases in regards to the order of protection that would affect the custody of the children.
So, what kind of evidence matters most in these hearings? For example, police reports, medical records, text messages, maybe prior DCFS findings?
All of the above. So the order of protection requirement says that you have the burden of proof is on the petitioner who files the petition, is to prove that there were at least 2 or more contacts that were prohibited by the law, or that the alleged victim asked the abuser to stop and he wouldn't. The evidence, everything that goes between people comes in. But the way it works for the judges always look at the very last occurrence. So what happened, what was the last action? What was the last activity? What was the last drop that caused you to go and file a petition for the order of protection? It can be domestic violence. It can be abusive text message. It could be calling to your work. It could be taking the child away from you. It could be violence towards the child. It could be damage to the property. So that's the first, like the last incident, right? So then the judge would ask you what happened before that. And that's important. The time frame is extremely important. So if there was an instance of domestic violence, let's say 6 months ago, and you want to file petition for the order of protection now on an emergency basis, you're not going to be given the chance to do that. I mean, you'll be given a chance to do that, but most likely it'll be denied. That's number one, because you have to, emergency order protection has to be an emergency order protection. So something has to happen, within very close proximity. The history matters. If there were prior DCFS filings, if a person was indicated, if a person has a criminal history, if a person had a conviction for DUI, driving under influence, if there is a history of drug abuse, violence, and things like that. But something has to be mostly recent. So in other words, the two things that you need to show. First, that there's imminent danger to your personal safety or safety of your children, meaning that if I come back home today, I can be killed, or he can hit me again, or there can be abuse towards my child. And I'm afraid to go back home, and I have no other place to go. Because if you have a shelter, or if you have a relative that you can go to, you might not be given emergency order of protection because you have a way to retreat. But if you have no way to go and you need this person to move out because you have kids and they have to go to school tomorrow, that's the reason for you to file for their emergency order of protection. And then you can attach prior history. You can go as long as several years back and show to the judge that this happened over and over and over. And one of the things that have been asked a lot when I work with victims, if previous history can somehow harm you, and the answer is no. The people are afraid to disclose things like that for obvious reasons. They don't want to make this a public information. That's number one. Number two, victim, from my experience, knowledge, and education, and I worked a lot in women's shelters, and I worked a lot in different shelters. Victim always trying to find an excuse to her abuser. So, and that's one of the red flags. Abuser will always blame the victim. Abuser will always say that this is her fault, that this is something that she did, or she's just a bad person. The victim will always try to find an explanation to the abuser. The victim would say, oh, he's just getting tired at work, or he just had a rough week, or something else. So that's why victims of domestic violence suffer a lot over their years, and they don't disclose, and they go forward and talk about the abusers because they don't want to make it public. They don't want to feel this shame of what happened, and they try to give the abuser another chance. So there is nothing shameful, and it's not going to work against you if you disclose this incidents and tell it to the judge of the past abuse. It's difficult, but if you want to make it stop, this is exactly the evidence that you need to present to the judge.
Well, thank you, Fedor. And that is it for today's episode of the Family Law Frontline. If you believe your child may be in immediate danger and need to understand your legal options under Illinois law, visit lawyer-il.com to connect with Fedor Kozlov and his team. Thanks for listening. And remember to like, subscribe, and leave a review so you will catch the next episode and forward this episode to someone who needs to hear it. Thank you, Fedor.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.